This court is cognizant of the fact that this hearing spans several months. However, the court would note that in the interest of justice, fairness, and in order to assure that due process was afforded, not just to the defendant, but also to the people of the city of Detroit, this court had to guarantee a complete and fair hearing. The court finds defendant's conduct in this matter reprehensible. Defendant has not only continued to flout the orders of this court, but has continued his disregard and contempt for the people of the city of Detroit. Defendant's plea agreement stipulated to repaying the citizens of Detroit for a fraction of the damages and monetary loss they suffered as a result of defendant's misconduct while he was in office. The order to disclose defendant's assets were entered in an effort to assess defendant's financial status and his ability to repay the city of Detroit after defendant brought this motion to reconsider the order of restitution, and after defendant asserted that after living expenses he only had $6 a month to apply towards restitution. Despite this order to disclose, defendant still engaged in obfuscation and attempted to undermine the intent of the order, which was to ascertain an accurate picture of defendant's assets. In light of the revelations that defendant and his spouse have collectively received hundreds of thousands of dollars prior to and since his release from jail, the defendant lives in a $1 million mansion in an upscale neighborhood, the defendant has secured a six-figure salary. This court finds it incredulous that the defendant would have the audacity to feign indigency. This court finds defendant's behavior as an affront to the sensibility and dignity of the people of the city of Detroit. Defendant's continuing self-serving behavior, fraudulent and deceitful representations, and general lack of integrity have forced this court to amend the conditions and terms of his probation. Conclusion. The intent of this order is to ensure compliance with the order to pay restitution in a timely manner. Consequently, the court thereby modifies the order of probation as follows. Defendant's probation shall forthwith be transferred back to the administration and supervision of the Michigan Department of Corrections Probation Division, and the defendant shall be monitored by an office in metropolitan Detroit. Defendant must report by phone on a weekly basis each and every Friday. Defendant's travel for business or other purpose must be pre-approved by the probation department. Defendant must supply the probation department with documentation that indicates where the restitution payment is coming from. The probation department will generate a monthly report and submit it to this court on the day after restitution is to be paid, with detailed information about defendant's compliance or non-compliance with this court's orders. Defendant will disclose to the probation department on a monthly basis with complete and accurate accounting of all finances or changes or modifications of the financial position of defendant and defendant's spouse, Carlita Kilpatrick, including but not limited to all assets, debts, income, gifts, valued at $100 or more, loans, tax returns, investments, investment accounts, retirement accounts, dependent educational accounts, bank accounts, credit cards, credit accounts, promissory notes, mortgages, residential leases, vehicle loans, vehicle leases, and any other personal or family financial transaction that might affect defendant's ability to comply with the order to pay restitution or impact defendant or defendant's family living expenses. This order to disclose is continuous and requires defendant to notify his probation officer of any updates or changes in the above enumerated items. Defendant must pay 30% of all funds deposited into Carlita Kilpatrick's accounts from Mr. Manny Maroon, which was $50,000, and Ms. Elham Shoyato, which was $15,000, per court order of March 10, 2009, within the next 30 days. That 30% amount is $19,500. Defendant must pay towards his restitution all money defendant or defendant's family received, moving expenses and park shelter expenses after October 28, 2008, from the Kilpatrick Civic Fund, which was in direct violation of the order of probation dated October 28, 2009, within the next 30 days. This amount totals $36,142. Defendant must pay towards his restitution all tax refund dollars as agreed to in his plea agreement within the next 30 days, which totals $23,369. Defendant must, within 90 days, pay towards his restitution $240,000, the amount defendant characterized and presented as a loan for the reason that the court is satisfied that the assets of said loan were immediately transferred to Carlita Kilpatrick as a fraudulent conveyance. The defendant will continue to pay 30% of earned income and gifts. The defendant shall pay the balance of the restitution owed to the City of Detroit in full within 48 months from the date defendant entered his plea, the purpose of which is to ensure compliance with the restitution order. All of the terms and conditions of defendant's probation remain in effect. Although it is the intent of the court to not set defendant up for failure, the court will remind defendant that the failure to meet the terms set forth in this court's order or any court order will result in a probation violation hearing and will expose the defendant to severe sanctions up to and including incarceration. The court will deny people's request for wage assignments and pre-approval of expenses. Therefore, and for the aforementioned reasons, the court hereby grants in part and denies in part the people's motion to modify the monthly restitution payment and probation terms. It is so ordered. And the court's going to sign an order to that effect. Now, before we break for the day, there was a motion filed by the prosecutor's office for a violation of probation hearing to be held. Ms. Syringas, what is the people's position at this point? Did people request that I set a hearing date, or do the people request I don't set a hearing date? What is your position at this point, since you filed the motion?
Well, Your Honor, we filed the motion. We'd hold that in abeyance, and we'll notice it up when appropriate if need be.
All right, if there's nothing further, then we'll stand recess.
Yes. Okay.